Thank you. In the fall of 2017, I decided to run for public office. This was not an easy decision for me to make. In my mind, I had always reserved political office and campaigning for people who had money and prestige. I never considered myself to be a political person, nor did I think I had the power or the voice to make people listen to me. Over a series of several nights leading up to making my decision, I thought constantly of my clients. The people who, seeing the immense sadness in their eyes, had pierced my soul many times. I thought of the times that their hopelessness had kept me awake at night, dreaming of a better justice system. Their family members and loved ones whose stories had shaped my mind and my way of thinking as a public defender for 10 years. My clients had often relayed to me the same sentiments I felt about why I shouldn't run for office as reasons they couldn't get a fair trial in the justice system. They were poor. They didn't believe they had any power. No one would listen to their voice. I realized in those reflective moments that the very reasons I was fearful of running for office were the reasons that I needed to do it, that I had to do it. I needed to catapult my frontline courtroom advocacy to a seat at the table where I could truly elevate my voice for my clients and create positive change. Being a public defender has been one of the greatest decisions I have made in my life, but it has taught me so much about how truly broken the criminal justice system really is, particularly as it relates to the treatment of poor people and people of color. I fear that we are beginning to overuse the term criminal justice reform as a buzzword without really thinking about the fact that it is a broad term that encompasses the many changes necessary to create a more fair and compassionate justice system for all. Criminal justice reform contains many components. In order for us to have a meaningful conversation about reform, we must begin by addressing the elimination of wealth-based detention. Money should not be the determining factor for whether a person remains in jail awaiting their trial. Money should not determine the type of justice that someone receives. Yet in America, when someone is arrested, a money bail amount is set in their case and is the most utilized method for someone to secure their release from custody pre-trial. According to statistics by the United States Department of Justice, there were 740,700 people sitting in America's jails in 2016. 65% of those people were awaiting court action in their case. They hadn't been convicted of anything, yet they sat in jail because they were unable to post their bonds. In Nashville in 2017, 23,054 people were arrested. 80% of those individuals had a money bail amount set in their case. Only 12% were released without cost. And 60% of people were unable to pay for their bail, and so they remained in jail, awaiting their trial. For us to have a real-time depiction of what that means, over half of the people in this auditorium represent the number of people sitting in jail simply because they could not afford their release. This is the tale of two justice systems. In one system, a person has the money to secure their release. They get out of jail, they return to their jobs and their families. They can freely assert their constitutional rights to a trial, to be presumed innocent, and they can prepare for their defense without the constraints or limitations of being in jail. In the other justice system, poor people lose everything they have sitting in a cage. Some of them even lose their life. This is Janice Dodson Stevens, a 61-year-old grandmother who was arrested in Bexar County, San Antonio, Texas, and charged with the misdemeanor offense of criminal trespass. Ms. Dodson Stevens had a lengthy history of mental illness, having been diagnosed with schizophrenia. When she was jailed on July 18, 2018, a money bail amount of $300 was set in her case. She couldn't afford to make that bail. She was unable to contact any of her family members. She sat in jail, not convicted of anything, for 5 months. And on December the 14th, 2018, Ms. Dodson Stevens died in custody. Right here in Nashville, my clients who are unable to post bail are locked in a cage in the county jail. They lose their jobs, mostly temporary assignments or hourly positions that can't be held open for them indefinitely. They lose their living arrangements, becoming evicted, having their items trashed or thrown on the streets. Their children and family members who rely on them are in limbo. Many of them get behind on their child support, and some even lose custody of their children. They have lost loved ones who have died while they were in custody, and they couldn't say goodbye. They lose their transportation due to repossession fees and impounding fees. And from the moment they are booked into the system, they begin building a debt cycle because court costs and fees are assessed in their cases, creating a bill they cannot pay, an account that gets sent to collections, damaging their credit worthiness. They are helpless, hopeless, and their spirit is eroding. Why is this important? Why are we even having this conversation? Because wealth-based detention erodes one of the very constitutional principles this country was built on, due process, which includes the presumption of innocence. The mothers and fathers, sons and daughters who sit in America's jails every day pre-trial are presumed innocent. Innocent. They are presumed innocent. And what happens to a person who is presumed innocent, yet they can't get out of jail? They wait for days, weeks, and even years before their trial date. They begin to seek the option that will release them from custody the fastest. They become desperate. They want to get out of jail. And so many of them enter pleas of guilty. They decide to forego their constitutional rights to a trial, to question their accuser, to have an attorney assist in the preparation of their defense by doing things like investigate their case. They are willing to risk creating a criminal record that will have collateral consequences like the loss of license, limited employment, education, and housing opportunities, and the loss of the right to vote, among many other things. In addition to that, studies show that people who are detained pre-trial are more likely than not to receive a jail or prison sentence, and more likely that that sentence will be for a longer period of time. Here's my call to action. I am asking you to partner with me and all of the other advocacy groups in raising awareness to the issues facing the criminal justice system today. To stand with me and use your voice in support of moving away from a system that is designed for retribution and punishment, concepts that do not create a better society and do not increase public safety, and move toward a system Invest in one that embodies the principles of rehabilitation, restoration, and reentry. I am asking you to commit to seeing the humanity and dignity in all people, especially those who have been charged with a crime. For they are more than defendants, and their lives are more than simplified statements on an arrest warrant. Have critical conversations in your circles where you are encouraging people to be a partner in the elimination of wealth-based detention and a supporter for the creation of community-based alternatives to people sitting in jail pre-trial. As a country, we cannot afford to wait to address the economic disparities in the criminal justice system. We can't sit idly by and watch poor people suffer, nor can we watch as poor people experience a different form of justice than those with wealth. We can't afford another Kalief Browder. Kalief Browder was 16 years old when he was arrested in New York and charged with theft of a backpack and its contents. There was an initial amount of bail set at $3,000 in his case, and his family was unable to make that. When they were able to raise the amount to release him from custody, a judge denied his relief. Mr. Browder sat in jail for 3 years, nearly 2 of those in solitary confinement. He was the victim of prison violence and endured many traumatic experiences while he waited. Despite the many times he asserted his innocence, his trial was continued due to a backlog in the district attorney's office. And ultimately, his case was dismissed for a lack of evidence against him. After his release, Mr. Browder suffered major depression. He referred to himself as mentally scarred and talked about how he believed that his happiness had been robbed from him. On June the 6th, 2015, Kalief Browder committed suicide. This is a moral issue. This is a community issue. Again, we cannot afford to wait. I told you at the beginning of my remarks that deciding to run for public office was not an easy decision for me, and it wasn't. But I am so glad that I did it, and I believe now more than ever before that there is power in my voice and people will listen. And now that I have told you about all of these issues, particularly the one pertaining to wealth-based detention, I am more encouraged than ever before by the partnerships that we will form, and we will together create a world of change and a world of hope. We have to do it. The time is now, and we cannot afford to wait any longer. Thank you.